Good afternoon and welcome to our last session of the day for oral arguments for the Court of Appeals. My name is Judge Gina Bating and it's my privilege to be presiding today along with my colleagues, Judge Mary Chikelli and Judge Samuel Langholtz. We will be hearing just one case this last session. That case is N. Ray J.B. and R.R. The appellant appears by Mackenzie Moran, and the appellee appears by Jamie Hagemeier. Ms. Moran, whenever you're ready.
Court, Counsel. My name is Mackenzie Moran, and I represent the appellant state in this appeal. This case is about Iowa Code Section 232.117 sub 3, and that governs the transfer of guardianship upon termination of parental rights. The section is clear and unambiguous, and it makes it clear that engaging in a qualitative analysis when appointing a guardian post-termination is not appropriate and is not warranted.
Ms. Moran, can I interrupt you and just have you pull the microphone down towards you so our video picks it up? Yep, thank you.
There are two primary errors that led the juvenile court to get to this analysis. First being that the juvenile court uses a particular definition of priority that led to the engaging of a best interest analysis where the code does not explicitly prescribe that. And second, the juvenile court used section 232.118 to guide its analysis in a case where that law does not apply. And so turning to 232.117, it states in relevant part that if the court finds guardianship and custody with the child's parents is not in the child's best interest, then guardianship and custody shall be transferred for placement of the child in any of the following categories in the following order of priority. It then says the department. And in listing the department, it does not simply say the department and move along to the next category. It says the department if HHS had custody at the time the termination petitions were filed, or if custody with the department is necessary for to facilitate the permanency or adoption goal, unless the department has waived that priority. There's no dispute in this case that the department had custody of JB and RR at the time the termination petitions were filed, and there's also no dispute that the department did not waive its priority here. Instead, the dispute here arises based on whether the language of this code section allows for a juvenile court to engage in a best interest analysis or a qualitative analysis rather than simply following the code section as described.
So can I ask you a quick question with regard to the interplay between your argument and the Supreme Court's decision in the recently decided Iowa Department of Health and Human Services versus Iowa District Court in Fort Polk County was decided on October 31st. I don't know if you've taken a look at that case, but how does our analysis here become impacted by that recent decision?
I think the case here still centers on whether the department has had an opportunity to fulfill those obligations as guardian. I think the mechanism for how that's dealt with maybe is a little bit guided by that recent case, but I think ultimately 118 is clearly talking about the removal of a guardian, not the appointment of one, and 117 has none of that language, and I think that that's important here.
Here, the department's plans were pretty firm that they were going to move the children to the aunt in Tennessee, right? And so if the department was appointed as guardian and custodian, the children would be removed, and then we would be reviewing that decision if an application to remove the department was filed. So doesn't that run afoul of the Supreme Court's decision stating that we need to be concerned about the harm to the children, not waiting until the harm happens and trying to stop it before it does?
As a preliminary point, the department is obviously concerned about those harms too. But again, I think that this is just a different situation, and the certainty of what the department's going to do, I don't think changes the outcome here. And I think that there is a conversation to be had about whether the department was being reasonable and responsible, and the state would submit that it was, and that's a different argument, I think. But at the end of the day, I don't think that changes the outcome in this case.
I agree that it's different statutes, but I want to explore kind of what your interpretation means with this statute. So if I understand it correctly, you're saying best interest of the child doesn't come into play at all. It's just going down the line through the priority. Am I misstating that, or do you think there is some role for best interest of the child?
No, I think that Explicitly isn't. There's other parts of Chapter 232 that use the word priority in the exact same sentence structure, and in those sections, that being Section 95, Section 78, and Section 102, after the priority categories in those sections, there's also a requirement that the juvenile court make best interest findings. The omission of that here, I think, tells us that the legislature didn't anticipate this sort of best interest analysis happening under 117.
So given that, suppose the department waived its priority. We went down from, the first priority of the department and then to the family member. Does that mean deciding whether to go from 2 down to 3, so from the family member down to fictive kin, that again, like if there's a family member at all, that's absolute? There can't be any best interest of the child analysis in deciding whether to pick that category or to go down to the next category?
Slightly different situation that, because like I said, here we have already the limiting qualifier of whether the department is waived, and those don't have that. So I don't know if that perhaps does allow for some more discretion because there's not a clear picture of when they envision it moving beyond. And also in those other code sections, the best interest findings are required for when you move beyond the first category, not as you go down the line. So perhaps the parallel, if you continue to use that analysis, doesn't necessarily require.
But, I guess as the back base drop, and again, this is colored by, as Judge Kelly mentioned, the most recent Supreme Court guidance that we, are obligated to always be considering best interest, or the juvenile court has to be able to consider that when making its decisions. Prior cases interpreting this statute before the 2022 amendments said that you'd choose amongst those choices from best interest. So what about sort of putting in a priority, expressly takes out best interest? Or what's the strongest kind of argument that that priority language is an abrogation of the old case law?
I think that all of those priority categories as enacted by the legislature are guided by the child's best interest. The department is usually the expert in the room about how to facilitate permanency, and that's if you want to have a subsidized adoption, the department has to be guardian at the time. So I think that that's embedded within the legislature's enactment of it.
Okay.
And so I think, again, turning to the juvenile courts, the problems that led to this analysis, I think that one, it's using the definition of priority and superimposing the best interest that we talked about. And then the second problem is that on the whole, this analysis is guided implicitly and at times explicitly by 232.118, and that code section simply just does not apply. That governs the removal of a guardian rather than the appointment of one. And at no point here was the department the guardian of either of these children. And a similar case was before this court last year, in which the court reached the same conclusion. And in that case, the Court of Appeals majority wrote that 232.117.3, quote, contains a directive mandating that the juvenile court should have transferred guardianship to HHS. And I think that this case is not so different from TT, and I think that it's helpful guidance here, and I think it shows us that 118 shouldn't be applied in this case.
Thinking aloud, I think, at this point in time more than anything else. But, if we were to agree with you that under 232.117.3, we've got this priority sort of hierarchy starting with the department, then is there room for, let's just say, the district court in these kinds of situations to say, all right, well, we're going to go ahead and stick to that hierarchy or priority schedule, but we're going to right away mandate that there is a hearing right after termination to determine best interests of the subsequent placement.
Like that sort of situation would also allow for the juvenile court to put in place some restrictions about what the department's going to do as guardian so that they can have that oversight that they're kind of concerned about in the recent cert case that we saw. So I think that that would be the mechanism. So barring any further questions, I think in summary, the juvenile court's primary error is engaging in this qualitative analysis. I think 232.117.3 doesn't prescribe that and doesn't require it. And I think that it's guided by a confluence of 118 and the superimposition of a best interest standard where it's not included. In the plain language of this code section, in addition to this court's recent decision in TT, it make it clear that the department should have been appointed guardian in this case. And so with that, the state would ask that you reverse.
You'll have additional time on rebuttal. Ms. Hagemeier, whenever you're ready.
Thank you. May it please the court, counsel. My name is Jamie Hagemeier, and our office represents these two very young children who are the subject of this appeal here today, as both their attorney and their guardian ad litem. Despite the state's arguments before the court, we do believe that the legal landscape has changed a bit since the ruling in October in Health and Human Services versus Polk County District Court. In fact, we think it changes or gives us the lens on how we're supposed to view and interpret statutes within Chapter 232. We do think that best interest should be included in any interpretation of the statutory language, especially when 232.117.3, that is very closely tied to 232.1116, which talks about the best interest piece when determining whether or not to terminate parental rights. And in that statute, it talks about what connection the child has with the foster parent when determining whether or not to terminate constitutionally protected parental rights. And so we believe that this juvenile court was correct in its interpretation of three key words in 232.117 sub 3, and those are shall, transfer, and priority. And we believe that it is a reasonable interpretation made by the juvenile court that the court must consider the department first, unless the department waives the right to be considered first, but it is not a mandate, as argued by the state, that the department be appointed as guardian. The juvenile court was also correct in that the shall means custody and guardianship shall transfer to someone within one of those four categories. If the legislature had wanted to limit the categories, they would have written it more similarly as they did for transferring custody to a parent. Right there in 117, it says, if the court cannot transfer custody and guardianship to the other parent, then this is what happens. And so the legislature could have added that language. It didn't. We believe that the department's interpretation would limit the juvenile court's ability to prevent probable harm to these two children and its ability to remedy that harm. Children should not be required to be harmed before the juvenile court could intervene on their behalf. When discussing a parent's constitutionally protected right to parent their children, the court is allowed to consider the parent's past behavior as a predictor of future behavior. And frankly, that same standard should apply to the department when reviewing their actions as a custodian of the children.
Respond to Ms. Moran's argument that the best interest determination is already baked into the statute so that it doesn't, if I understood her correctly, so that it doesn't have to be made by the juvenile court. The legislature has already determined that it's in children's best interest to be placed with the department as guardian and custodian.
I don't think that can be baked in. I mean, the facts of each specific case that the juvenile court deals with are so fact-specific, and one little thing can change the outcome. And so I think that the juvenile court has to have that discretion. They're the ones on the ground to make those best interest determinations. This case had a lot of problems from the get-go. The child was placed with an inappropriate suitable other, leading to the youngest one being hospitalized and the kids being cared for by a registered sex offender before the department was required to address that issue by the juvenile court when it was brought to their attention by our office. The department spent months not facilitating a relationship between this aunt and the children until our office intervened and said, hey, you need to make sure these kids meet this aunt, and that was June of 2025. Again, there was no in-person contact until September of 2025 when the aunt was here for 9 days and the department didn't schedule visits. These are things that are very fact-specific within a case and things that the trial court will know. In the record before the court today, an expert witness in infant mental health testified that these two children, if moved as proposed by the department, she had no doubt that it would cause these two children irreparable harm. The juvenile court correctly found, after hearing all the evidence, the process that HHS employed and the plan that resulted is flawed and shows reckless disregard for the children's mental health. The risk that HHS is willing to take in order to place the children with a relative they do not know is unreasonable. The risk is higher given the children's specific histories, which did not seem to be a factor into the HHS's decision-making process or decision. And the juvenile court in this case was very comprehensive in its ruling, and it appears to have taken a three-step analysis in order to give that department the priority or the consideration it was due as the primary or the priority, having the priority to be guardian.
What is your view of what the priority that the statute gives should be? You know, is it just consider in this order? Do you have to give some sort of extra weight, you know, when you're thinking about the best interest? Well, maybe this wouldn't be in the best interest if this person were only fictive kin and not a family member, but because it's a family member, that gives it an, like, how do you do best interest analysis and the priority at the same time if that's how it's supposed to be?
I think the priority means you need to give the department deference. And the Supreme Court has talked about giving deference to the department when making their decisions. And what our Chief Justice has said about giving them deference is that giving deference to the department's placement decision does not mean blind acceptance that freezes the juvenile court out of any meaningful review of HHS's decisions. There's a difference between reasoned deference to the opinions of professionals involved in the case and blind acceptance of substantive matters.
About the difference between 232.102 and 232.117, and how that would impact the application of the Supreme Court's recent decision here. Specifically, 102 provides or states that the selection is subject to review at the request of an interested party, and we don't have any similar review language in 117 sub 3. That was a long question, I'm sorry.
In my head a little bit. I think what we see from the case law that's developing under 232.102 is that the juvenile court is able to choose a different category of care or a different category of placement than what is being recommended by the department. I think that when the language in 117 where it says shall transfer custody and appoint a guardian, it doesn't, I think that's inherent that the department or the judge gets to make a decision on that.
So it doesn't need to specifically state that there's a review, there can be a review? Okay, gotcha.
Once the guardian is appointed, then Chapter 232.118 does give us that standard to say when the guardian should be removed.
So if we accept your statutory interpretation argument and affirm what the district court did, what process is the court supposed to apply under 117 sub 3? Because it does seem like the court adopted the standards in 118 when making this determination.
The court actually did a three-step analysis, and I think the first step was determining best interest, and I think the court used the guidance that this court has provided in Ray LP and AS by saying we're going to adopt the 232.116 sub 2 when doing the analysis of those categories of care placements under 102 that you just mentioned. And then after she did that detailed analysis under 116 for best interest, she did take that high burden of proof of showing if something was unreasonable and irresponsible, which the court did find. But then she also took a third step, and I think that comes from the Supreme Court case from In re Katie from 2022, where she talked about the process and the department not following its own process to prepare children and select the adoptive placement. And so I think based upon those three steps, she really honored the statute and the case law that is developed. Thank you.
Counsel. Rebuttal?
you. I think I'd like to start with just a couple like factual points. In reference to the expert that testified, the state would just also note that that expert had not met these children at any point, and the children were under the age of 2, and so I think that's part of why there hadn't been as much involvement with mental health services. But secondarily, the worker also testified that she had heard the guidance of this expert and was going to implement as much of that as possible when contemplating a move for these kids. But overall, I think the problem with the appellee's approach and what happened in the district court order is the ambiguity and the need to rely on all of these other code sections in order to reach this analysis or this conclusion. 232, 117 is right next to 116 and 118 and doesn't include the language that we're using and trying to infuse into it here. And the other point I would say is, circling back to the ambiguity, the code doesn't say, unless the department waives its priority, or unless the juvenile court finds that the department acted not in the child's best interest as custodian or unreasonably irresponsible. It doesn't include that language, and I think that if the legislature intended for that to be the standard here, they would have included it. And so with that, the appellant state would just respectfully request that this court reverse the juvenile court and remand with instructions to appoint the department as guardian of JB and RR.
Both for your good briefing and excellent arguments today. We will consider the matters submitted and have a ruling out as soon as possible. With that, since there are no other cases, that concludes our oral arguments for today, and we will reconvene tomorrow morning. Thank you.